Okay, we're breaking down that video, and now we have to talk a little bit more about it and what the defense is trying to do. So joining me right now, I have a very special guest, criminal defense attorney Ross Kramer. Ross, great to have you back here on Law and Crime on such a late hour on a Friday.
Yep, happy to be here.
So what is the defense doing here? Are they poking holes in that video and saying, you know, you might see one thing, but how accurate is this video? Is that what they're trying to do?
Yeah, these videos are not perfect, and a defense attorney is trying to make what he can out of it. On a video like that, it's difficult to see distances. It's taken at night, so the lighting isn't perfect. You're really doing as much interpretation as you can of that video, and when you get to that point, both sides are trying to do the same thing, to spin it one way or the other.
Well, what about the video would I look at if I'm a juror and say, it's presenting more questions for me for answers, because if I look at it, I see Laquan McDonald walking down. I see him walking in an area away from the police when he's gunned down by one officer. Unless you can argue, hey, in that very last shot, I don't quite see, it kind of cuts off Jason Van Dyke. Is that something that you can explore?
Yeah, you're really trying to explore what that video would have looked like, what the situation in the scene would have looked like from the point of view of the officer while he was standing there. When you're in a stressful situation like that, things are happening a lot faster than they may appear there. Things may be a lot more confused. You can understand the backstory to what happened before that started getting captured. And I think if you're a defense lawyer, you have to argue, put yourselves in the position of this officer here where he's not sure what's going to happen next. This is a really moment-to-moment interpretation of what's happening there. And he was scared.
Okay, so we talk about what the defense is going to do. Let me ask you, what are they going to do? They're going to start their case on Monday. Do they call the defendant on the stand?
I would doubt it in a case like this. I think that's a very difficult position to put him in. I think they're arguing here that this was a reasonable action by an officer who's in a very stressful situation, that this is a unique situation for anyone to be in, to be there with a person who's obviously armed, who's they're going to argue is acting erratically, and that he took the action that he thought was reasonable and necessary at the time.
But if you don't put him on the stand, you're not getting his insight into what he was feeling that day. That's why we see so many defendants take the stand in self-defense cases or defense of others cases.
You know, it may be the most difficult decision that a defense lawyer, along with the defendant, has to make. And this is one of the decisions where a defendant really has to be involved and make for himself. On one side, you get his present sense impressions of what he was thinking, what led him to take the actions that he took. But on the other side, you're opening him up to cross-examination, and a skilled cross-examiner can make even a very credible and very honest witness look like there was something else going on there.
Yeah, that video, you couple it with that, it's a difficult case for the defense any which way you slice it. When we get back, though, we're going to play the testimony of a very controversial witness, and Ross and I are going to talk about whether or not he should have taken the stand. We'll be right back, right after this. All right, so you saw all that testimony? Well, guess what? The judge threw all of it out. He said that it was improper for this expert to hold himself almost out as a ballistics expert, or even to rely on the opinion of a ballistics expert, because that's going to confuse the jury. That's not his qualifications. That's not his expertise. He's a video analyst. Now, that's a weird thing. Let's bring in Ross Kramer to talk a little bit more about it. Ross, do you think that's an appropriate ruling by the judge to throw out that entire line of testimony because he puts those green arrows in the video and talks about ballistics? I mean, that is not his specialty.
Yeah, I mean, this is exactly what a judge is supposed to do in these kind of cases. A judge is not giving evidence. The judge is not determining the credibility of evidence. That's for a jury. But the judge is the gatekeeper. The judge has to be the person there who determines what evidence is sufficiently reliable for a jury to hear. And with expert testimony, that's particularly important.
Now, he was called back to the stand, but the judge telling the jury, disregard everything you heard from him, even his name. Juries are human beings. They're not computer tablets. They can't just, erase stuff. What does that mean? So whenever you're in a courtroom and they say to a jury, disregard that comment, disregard that testimony, throw it out, realistically, what happens?
It's very difficult. You know, the saying is you can't unring the bell. Once a jury has heard a certain piece of evidence, the judge instructs them and probably gives the instruction repeatedly that they're not to consider that piece of evidence when they retire to the jury room and begin their deliberations. But that is very difficult. A jury does, on the other hand, understand how serious a case like this is and that somebody's career and liberty are at stake here, and I think they try their best to take the judge's instructions at face value and try to concentrate on all the evidence they're supposed to be considering.
But the risk of prejudicing a jury is very high in every kind of case, right? Even the smallest comment can resonate in a juror's mind.
Absolutely, but this happens in every trial to one degree or another. Lawyers are human beings. The judge lets things go that shouldn't go before he can cut them off. It happens, and the jurors have to do their best. The judge has to do his best, and lawyers have to do their best to make sure that that kind of thing doesn't happen in the first place.
Well, we are going to have to see what happens, because Monday is a big day. Monday is when we see the defense begin their case, and you've seen them already put on their opening statement, cross-examining these witnesses. You saw they got the testimony of that witness thrown out, and new testimony had to come through. When we come back, we're going to talk more about the Jason Van Dyke case, because there are so many different facets of it to analyze. But really, we always have to come back to that dash cam footage. So we'll take a quick break. We'll be right back. Stay tuned here on Law and Crime. All right, so that was Scott Patterson, FBI Supervisory Special Agent of Ballistics. Back here with criminal defense attorney Ross Kramer. Ross, the idea, what we keep seeing here between the defense and the prosecution is how many times was Laquan McDonald shot and when did he die? We heard testimony that he felt every one of the gunshots and that he was alive longer than was anticipated. So if I'm sitting in the defense's chair, am I worried?
I mean, absolutely. I think that a lot of this evidence that's coming in makes you worried. This is the difference between reasonable force on behalf of law enforcement and excessive force that turns into a murder at this point. You look at that dash cam video and you combine it with an FBI technician's testimony that a lot of those shots appear to be when this victim was no longer a threat to anyone.
What would you say to the argument? We had a law enforcement expert on who says there's an idea out there that when you are an officer and you take out your weapon, you have to do whatever you have to do to put down that threat, including maybe unloading your weapon.
I would say that when jurors go back into a jury room at the end of the day and they're the final arbiters of the facts and the law and they bring their common sense back there, I think that's going to be a very difficult argument for them to swallow about what's reasonable and what's not reasonable behavior on the part of law enforcement agents.
Bottom line, it's not an easy job for the jury.
It may be an easy job when they have this much expert testimony and a video like this.
Well, we're going to have to see which way it goes, but we have a lot more to analyze, and Monday's a very big day. As we said, this is also the continuation of the Jason Van Dyke case, but we're also going to be covering a new case, the Jessica Chambers case. So we'll talk more about that on the upside of the break. Stay with us. We have a lot to discuss here on Law and Crime. We'll be right back after this. All right, we got to talk about this now. You heard the prosecution, you heard the defense. Now I want to hear from criminal defense attorney Ross Kramer. Ross, you watched that. You watched the back and forth there. How important is it, realistically, what was in Laquan McDonald's system, the fact that he was acting erratically, and the fact that he did have in his hand a knife? How important are those factors? You can look at the exact moment of the shooting, but how important is it what was going on right before?
You know, those factors are important. What's really important, though, is what was in that officer's mind at the time he was confronting the victim in this case. And, you heard the prosecution say he didn't know the results of those autopsy reports at the time. You heard the defense lawyer say that he was taking bizarre, abnormal actions, but in his definition, those actions were walking slowly with police officers behind you and not responding to their commands. I think that's a very difficult uphill argument to make, that those actions were so bizarre that they justified the use of deadly force.
What's the worst piece of evidence against him? Is it the fact that he's the only one that fired, that there were no other civilians in the area, that there's a taser unit right there, that Laquan McDonald was walking away seemingly from the officers? What's the most incriminating piece of evidence against him?
You know, it's the legal terminology here is the totality of the circumstances. Anyone watching this video and hearing the testimony, I think, would look at this and say, it doesn't look like there's an imminent danger to either the officers or to anyone else. You don't see anyone else in that video who looks vulnerable at this point. So you really have to look at the full situation.
You really do. And we're talking about use of force, and you and I can speak about it. But when we get back, we are going to play the testimony of Yuri Patrick, who is a use of force expert. And perhaps we'll get a better understanding of when it is appropriate to use deadly force and when it's not. So stay tuned here on Law and Crime. We have a lot to discuss here in our afternoon segment. We'll be right back. This is a key witness, the use of force expert, probably one of the most important experts you can have testify in this kind of case. Back here with Ross Kramer, what use of force experts, do juries rely on them?
Yeah, I think they do to some extent, although they're also going to take their own common sense back into the jury room. They'll look at this as if their own experience with law enforcement and their own experience as a person. But this was very powerful testimony. He not only concluded that the first shot was unjustified, but that the follow-on shots were unjustified. That, by looking at the totality of the surroundings, that this was a person who was hemmed in. And I thought one thing that made him sound very credible was that he said, you look at those other officers there, and they were all acting responsibly. They were all doing what they should have done based on the fact that there was no immediate threat to either the officers or anyone else. It's just this one rogue officer who acted irresponsibly under the circumstances.
So I'm going to ask you the question I asked you a little while ago because I want to see if it changed at all. You really don't believe that they're going to call him to the stand? You really don't believe the defense is going to call Jason Van Dyke to the stand? We've seen it happen so many times in these kinds of cases.
I'll give you the same answer. I think it's a very difficult decision, and I'll tell you, I don't think that decision has been made right now. From my experience in these cases and watching other cases, that's one of the real critical decisions, and it goes down to the wire. They're probably preparing with him as if he's going to testify, but they'll audible that at the last minute. Okay,
well, we'll have to see. Want to give our viewers an update on Stanley Liggins. As you know, the jury just asked to hear audio recordings of Antonio Holmes and Sherry McCormick. They wanted to hear those interviews. The judge says the Holmes audio was admitted as a demonstrative exhibit that does not go back to the jury room, and the McCormick audio was not admitted and was only played to refresh the memory of a witness, so the jury won't get that either. At the end of the day, they're just going to have to rely on what they remember and what they heard, and we'll have to see if they continue to be deadlocked. We'll be right back after this. All right, everybody, this is a witness that was definitely worth mentioning because he was right there analyzing every aspect of the police force and what they did. I want to bring back in our very special guest, criminal defense attorney Ross Kramer. Okay, the idea of the different ways that they tried to subdue this victim, you can't help but forget that he had a knife in his hand, was acting erratically, and was slashing parts of the car. I mean, again, we've talked about that distance and time. How does it work from a legal perspective? If he just did something that was a violent act, then it translates into him still being in danger a minute later, 30 seconds later. How does it work from that legal perspective?
Well, I think it's at the time that that officer decided to fire his weapon that you have to look at it. You look at it at the time when the victim was actually slashing a tire and swinging at a police car. Nobody shot at that point, and you heard the police officer who was in the car. Didn't sound like he was scared for his safety or anyone else's safety. It would seem that the circumstances de-escalated after that point. The person was walking away.
Does the defense bring in their own use of force expert on Monday?
It's possible. I would think that they would try to defend this case based on expert testimony rather than having the defendant himself testify. But, Jesse, you might be right. The defendant might have no choice at the end of the day. But this is very powerful testimony from a police officer who was there and acted completely differently than the defendant.
I have no idea, but I wonder if they'll call other witnesses who have a different view of the danger that Laquan McDonald presented. We'll have to see.
There may be. You see on the video one perspective, and it's from one angle. You can see there were officers that were standing in many different angles and followed this from a point in time way back.
All right, a lot to discuss here with the Jason Van Dyke case. We'll take a quick break. We'll be right back. Stay tuned. Okay, so let's talk about the defendant right now because there's one important aspect that the jury might not know, but we know. Back here with Ross Kramer. Ross, did you know that on at least 20 occasions in the defendant, Jason Van Dyke's 14-year career, Citizens have filed complaints against him. In fact, one man was awarded $350,000 after it was determined Van Dyke employed excessive force during a traffic stop. And in fact, most of these allegations were about excessive force. And in fact, in one complaint, it was alleged that he used a racial slur. So from our perspective and our viewers' perspective, what do you think about that?
Well, look, that's very significant evidence, but it's evidence that a jury in this case shouldn't hear, because there's too much of a risk that a jury would base their decision on what happened here on what may have happened in the past. And this is a big issue because jurors are instructed throughout a trial by a judge not to look on the internet, not to read stories about the case that's going on, not to check Facebook. Stuff like that is out there, and there's a very real risk that one or more jurors will go online and find that kind of thing.
But from our perspective, if this is all true, why was he still in the police force?
That's a good question. I mean, you would hope, I know you did the interview with Jesse Jackson earlier, you would hope that these are the kind of reforms that are going to be made to law enforcement where cops who show questionable judgment over time aren't still there, where it gets to the point where you need to have a criminal trial.
You know, as lawyers, we always ask, but for, if that was that one thing that maybe if he was not on the force, Laquan McDonald would technically still be alive. You would have to imagine, yes, maybe this scenario would have still happened, but no other officer fired their weapon that night.
But sometimes it takes criminal trials and highly publicized criminal trials to create real social change.
And here on Law and Crime, that's what we're doing. We're publicizing it and letting our viewers see one way or another. We'll take a quick break. We'll be right back. Stay tuned.